with respect. Thank you, Deputy Speaker.
I thank the honourable member for Chisholm. The question is that these bills be now read a second time, and I call the honourable member for Fisher.
Thank you, Mr Deputy Speaker. I rise to speak in support of the National Anti-Corruption Bill. It's not. It is an equivocal support, though. I've grappled with this bill. There's no doubt in my mind that people who are in positions of responsibility have an onus to always be acting responsibly, to be conducting themselves in accordance with the law. No one is above the law, whether it's a politician, whether it's a judge, whether it's a public servant, a member of the ADF, doesn't matter who we're talking about. No one is above the law. It's one of our principal tenets of our criminal justice system in this country and, in fact, in many Western countries. Corruption is wrong, and it should be stamped out where it is present. People who break the law should face the law. I want to talk a little bit about, having said that, some of my concerns with this bill. I have some concerns about, given what are the draconian measures of this bill, where people no longer have a right to silence. They are compelled to give evidence. Now, if you are on charge, if you've been charged and you're on trial for a criminal offence, and you are in a court of law, you can insist on your right to silence. A court, or in fact even an investigating police officer, can't compel you to answer questions. It's one of the fundamental principles, once again, of our criminal justice system. And yet, in these ICAC models, pretty much across this country and in states and territories, and what will likely be the federal model that's being proposed, you don't have that right. That right is stripped away from you. And as a person that used to represent criminals or alleged criminals many years ago, I have some fundamental concerns about that. You know, the criminal justice system provides people who are alleged to have committed offences greater rights than what this bill will do. And I know some people will say, yeah, but this is not a court that makes a finding of guilt. Accept that. And I think that what saves this is that these hearings will be done in most instances behind closed doors. What really, really worries me, and I want to get this on the record, is the politicisation, the potential politicisation of this forum. Someone who could be acting with mala fides could make a complaint and against a parliamentarian, for example, an opposing parliamentarian who might have it in for that person could make a complaint to the Commission. Now, we are kidding ourselves if we think that that's not going to happen. Unfortunately, it's going to happen. And it is the sort of pressures, I know people who have appeared before these sorts of commissions, and the sort of pressures that people will feel, I wouldn't say duress, but the extreme stress that these bodies put people through. These are things that we should tread very, very carefully on. I do acknowledge the model before us will predominantly have closed hearings, unless there are exceptional circumstances and unless it's in the public interest to have a public hearing. But we should also be very, very mindful that this bill is not just, and Australians who may be listening to this or reading this at a later time, this bill does not just, it's not a politician's corruption commission. It will capture Australian public servants. It will capture members of the Australian Defence Force. It will capture people who are working in the NDIS system. It will capture anybody who is working in the Commonwealth Public Service, or in fact people who are contracting to the Commonwealth Public Service. So it is not just a politician's commission. So I think that's really quite an important point to make. Having said about some of my concerns, Mr Deputy Speaker, I won't wrap up there because I've still got another 8 minutes, despite you wanting to wrap me up, let the record show. But the coalition, I'm happy to ask for an extension of time. I'm just warming up. The coalition was the first party to seek or in fact implement a corruption commission back in 1988. So we have, as a Conservative political force, been the groundbreaker. While we support the NAC as a party, it's important, as I've said, that we take serious care to get the balance right. We've engaged in this process in good faith. We have engaged in good faith through the parliamentary processes, through the committee processes. We're committed to being a constructive opposition. The coalition opposition is supportive of good policy where it's good policy, but where it's not, we will call it out. Now, I am concerned about the double talk that those on the other side of the House talk about. They talk the big talk about integrity. But what we've seen in the last couple of weeks in this place is through their secure jobs, better pay bill that passed this House in the last sitting week was the abolition of the ABCC. Now, I'm not going to talk at any great length, as I normally do, about what Labor do in relation to the ABCC. But what's quite amazing is that they talk the big talk about integrity, and yet when it comes to the CFMEU, which is the federal court has acknowledged as the greatest recidivist organisation in Australia, they've removed the watchdog in relation to that union. Of course it's a different bill. I'll take that interjection. Of course it's a different bill. The principle remains the same. You either believe in integrity or you don't. And where you profess the importance of integrity, then you can't stand up on the same dais and say, but the most recidivist organisation in Australian history should not be under the same rules, that it should not have some form of an integrity commission. Well, those members opposite should reflect on that very fact. Now, interestingly, this bill effectively provides a carve-out for unions. Now, those members opposite will quibble with that. The Attorney-General will quibble with that. But sections 12 and 14 make it very, very clear that the unions are getting a carve-out. So not only are the CFMEU getting a free ride here through the abolition of the ABCC, but they get a carve-out of this bill. And for the life of me, I don't understand how the media and the crossbench are not jumping up and down about this very point. So, Mr Deputy Speaker, Australians are, whilst they want integrity, they want integrity across the board, not some sort of a la carte integrity. Now, one of my other concerns about this bill is in relation to gag orders. Now, this place has just gone through a torturous process about acknowledging people's mental health and the well-being of workplaces. And yet this bill, in my view, does not appropriately provide for the care and well-being of individuals who may be the subject of investigations. Now, I note that the Attorney-General has just put out a press release today making some amendments in that regard. I haven't had an opportunity to go through that point in any great detail, but if someone is the subject of an investigation, then surely, for goodness sake, that person should be able to share the fact that they are the subject of an investigation with their doctor or their psychiatrist or a psychologist. And if their partner is not also the subject of similar inquiry, they should be able to share it with them as well. Otherwise, that individual is left totally exposed on their own. Now, you think about the sort of pressures that would be brought to bear on you as an individual if you were the subject of an investigation and you could not tell a soul. Have a think about what sort of impact that would have on you. Now, some of the amendments that we are looking at as a constructive opposition are in relation to public hearings. We believe that it should be compulsory for the Commissioner, when considering whether it should be a public hearing, compulsory, not optional, for the Commissioner to consider factors including whether confidential information is involved, whether there would be unfair prejudice to a person's reputation, or whether a person giving evidence has a particular vulnerability, such as being under direct instruction or control of another person. When it comes to telecommunications warrants, I've seen that the Attorney-General has also put out an amendment today in relation to making the decision-maker of those warrants a superior federal court judge. That's common sense. To have those sort of decisions about warrants being issued by AAT members, no disrespect to AAT members intended, but these are very, very serious things to issue warrants in relation potentially into politicians. Could be the Prime Minister, for example, could be the Chief of the Army or Chief of the Defence Force. It's very important that that issue be considered by a very senior judge, and I'm sorry that an AAT member, given that particularly they don't have security of tenure, that they just aren't, in my view, properly equipped to make those decisions. I'll leave it there, Mr Deputy Speaker. I could go on for hours, but I won't.